So we're in this area where we're talking about brand building and the opportunity of scaling and the opportunity of growing. And we spoke a little bit about trademarks and the process and all the things related to trademarks. And now we're going to talk about copyright. And copyright actually, it's a lot more simple than you may think, because there's one basic principle of copyright which applies throughout. And that is, when an artistic creation is made, automatically copyright is vested into it. So if you write a book, if you write a sentence, if you write whatever it is that you're writing, or any sort of artistic creation, the moment that you create it, that is when the rights apply to it. So a lot of the times people will say, oh, I've written a manual, but I haven't registered the copyright. Am I in trouble? And the truth is, no, you're not, because from the moment that you created it, you have the rights to that particular copyright. What happens is, there are complexities, as with many things. But one of the complexities is that, okay, you've created something. How can you prove to the world at large that you in fact have created something? It's highly encouraged for you to register your copyright, which is a pretty easy process. And all it really does is say, like, hey, I created this artistic performance, or I wrote this book, or I wrote this manual, or teacher training, or the 5 steps to writing something, whatever it is that you've written. Once you create something, the copyright automatically applies, but you can go one step further. And I always encourage clients to go one step further. And in doing so, what you're doing is registering your copyright. So let's say I've written a manual called How to Make Law Fun. And it's 8 steps about different ways that you can make law fun. An example would be like smiling, drinking coffee, being in nature, exercising, all of the things that I find ways to make law fun, I can share with you. I write it, I post it on my website, I've got a blog. The moment that blog is published, the moment whatever I write is published or live or accessible to people, at that point, I have the copyright in it. The encouragement that I always provide to clients is to register the copyright. So what does this mean? This means that you're gonna take something that you've written, so like the 8 steps to make law super fun. I'm going to go online, I'm going to register it. What you're doing by registering is you're saying to both the Intellectual Property Office or the Patent and Trademark Office, you're saying, hey, I wrote this, look how cool it is, and now I want you to acknowledge that I'm the one who's written this by giving me a certificate. Now, a couple of things to know about a copyright certificate. One is that no one actually monitors what you're submitting in order to speak to how true it is or not. So they're not like, oh, we reviewed the 8 steps to making law fun, and yes, in fact, we know that it is written by you, Corey, and as a result, we're happy to give you this copyright certificate. They'll just give you the certificate off the bat and trust that you're applying for it in the appropriate way. When you have that certificate, then you can take something and you can license it out. And if you've written a book that has copyright in it, clearly the copyright belongs to you, and because you have that asset and you have that content, you're allowed to then go and give it to someone else. And also, it lets you really pinpoint specifically what you've created, what you own, and then what you can then let someone else use either for free or for money. Now, people always say, and by people I mean clients, now clients will always say, okay, what if someone else registers a copyright for something that I've written? And I say, that'll suck, but we can fix it. And what you should do is go back and keep as clear evidence as possible to show that you, in fact, were the person who first wrote something. And there's a myriad of ways to go about showing this, but like I always say in law, it's not about what happens, it's about what you're able to prove. So let's say you've gone about writing a particular work or some form of artistic performance. Document as clearly as possible when you wrote it, maybe if there's someone else around who saw you write it or was maybe helping you in doing it, and ensuring that there is a foundation that if someone else is trying to take credit for something that you've done, you have a really easy way to show them like, hey, look, it's saved on my computer from this date. I sent an email to this person outlining it as my material on this date. And the more support that you can have for something, the better. So as much as it matters what really did happen, the more substantive proof you can put behind it, the better it'll be for you. Copyright issues can also come up for different artistic works like in video or photography, where let's say I have a photographer taking a picture of me. Who owns the copyright in that? Who owns those rights? Does it belong to me because the photos of me? Does it belong to the photographer because they've taken that picture? Photography and media law is totally separate, but I just want to put a really important reminder into your mind and something for you to consider and always think about. If you're doing anything that involves an artistic creation, be sure to clearly outline before working with someone what property belongs to you and what property belongs to them. The rule of law is there's always like these different rules that government has for videographers and photographers, and those rules are going to apply unless, ready, super fun, unless you agree otherwise. So if I'm working with a videographer who's helping me record an online course and we sign an agreement that says specifically, hey, this is the amount of money that I'm paying you to record this. In exchange for you accepting this job and recording this video, you forfeit all rights that you have to ownership or use or distribution of anything that you record while we're together. Videographer signs it, we're money. Same thing with a photographer. If I'm working with a photographer and I hire a photographer and I say, okay, cool, like I'm so stoked to have you capture fun images and I'm so looking forward to this relationship. But before we actually work together, let's be super clear about who's gonna own it, how I can use it, and any other issues that might come up between us. In summary for copyright, remember, any artistic creation, photography, video, anything that you write, the moment that you create it, you have rights to that creation, you have copyright rights. Registering a certificate, you will receive a certificate. It doesn't have anything to do with the registration or the patent and trademark office or the intellectual property office saying like, hey, we really know it was you. It's more them saying like, cool, good job, you're registering for a certificate. We're happy to give it to you that you can show to other people. But if you get challenged on that, the certificate doesn't mean that it's for sure yours. So rights exist once you create it, you can register for a certificate. And then when you're working with other people and you're in the realm of creating an artistic creation, like a dance sequence, maybe if two people are working on a dance sequence together, or you're co-writing something like a teacher manual or a training manual, you want to be super, super clear with the people who you're working with before you work with them, who the rights belong to and what the intentions of you and that person working together are. And I'll just share an example with one of my yoga clients. What happened was they had co-written a teacher training for yoga, which is fairly common. And then one of the people who was not my client ended up moving away some months later, and my client continued to run the training. However, they collaborated on creating that particular teacher training themselves, and in doing so, did not write any agreement. So the assumption is two people worked on something together that they were writing. Copyright is like mixed together. They both have the rights to it because they didn't agree otherwise. My client continued running the training, the other person goes away, but then catches wind and it's like, oh, you're using that manual that I actually helped create. I want 50% of what you're selling the course for because you're using the materials that I helped create. And that's another example of pay me now, pay me later. If that particular client had a copyright agreement or a service agreement or a contractor agreement with the person they were working with and said at the start, look, so jazzed about your yoga practice, so inspired by the insight and the contributions that you can make. We're paying you to help draft this teacher training manual, but we get to keep all of the rights to it and the copyright belongs to us and we can do whatever we want with it moving forward. And the money that we're paying you is in exchange for you both writing and giving us the intellectual property rights. If they would have done that, chick-chuck, super easy, everyone's cruising and in Shavasana and meditating. Unfortunately, it didn't happen in that particular case. And then we spent a lot of time in negotiations between the parties, probably spending 2 times or 3 times more what the original agreement would have cost if they just would have set the rights out from the beginning. So if it's just you writing something, super easy, you can register a certificate. And remember, get as much proof as possible that you were writing something when you wrote it so that if a scenario comes up where someone else might be trying to take credit for it, you can show hey, I sent an email to myself or I sent an email to my mother or my friend or my dog, saying that this is what I created, and you can show that to someone else, perfect. We love that. If you're working with someone else and you're working on a collaboration to create some form of content or artistic contribution, just communicate. Communicate your way through it and say, look, we're writing this together. Our intention is that we both keep ownership of it. Our intention is that one person keeps. Whatever you want, as long as you're agreeing to something that is not illegal, you can do whatever you want. So that's copyright in a nutshell. The super cool thing about copyright is right off the bat, after you make something, you've got the rights to it. The next steps are, okay, how can you show that you have those rights? And then if you're interested in working with a third party, what's the best proof you have that you actually own what you're saying that you have? And that was pretty fun.